Hello friends, very warm welcome to my business laws channel. Today friends, I am going to take up the topic conversion of partnership firm into LLP. Partnership firm can be converted into LLP or private company, or the unlisted public company can be converted into the LLP. Now the question arises, why partnership firm would like to be converted into LLP? So first of all, I will discuss need for conversion. Then what is the meaning of conversion? When is the partnership firm or private company or unlisted public company is eligible to be converted into the LLP? And then what is the procedure of conversion of partnership firm into LLP? And lastly, I'll take up the consequences or effects of conversion of partnership firm into LLP. So let us start now. The very first heading I told you, that is need for conversion. So advantages of LLP form of business outweigh those of the traditional partnership. So limited liability, perpetual succession, and unlimited partners are the key incentives for a partnership firm to be converted into the LLP. Because we all know in case of partnership firm, liability is unlimited. And moreover, partnership firm is not the separate legal entity. Okay, and there are limited partners, but in case of LLP, we know that, unlimited partners. There is no limit on the maximum number of partners. Now, what is the meaning of conversion? The conversion of the partnership firm into LLP means the automatic transfer of the property, whether tangible or intangible, movable assets, immovable assets, tangible, trademark, goodwill, patent rights, assets, interest, rights, privileges, liabilities, obligations, and whole of the undertaking of the partnership firm to the LLP as a going concern. On compliances of all the formalities relating to conversion, all the partners of the converting partnership firm shall become the partners of the LLP, and they shall be bound by the provisions of the second schedule. So friends, there are two entities now. One is a converting entity, which is a partnership firm, and second will be converted entity, which will be the LLP. Now, when is the partnership firm eligible to be converted into LLP? And there are various eligibility conditions. I'll take up all the conditions one by one. The conversion of the partnership firm into LLP shall be done as per Section 55 of the LLP Act 2008, along with Schedule 2 of the Act. The Partnership LLP Act has got 4 schedules. Schedule 1, 2, 3 and 4. Schedule 2 to 4, they deal with the conversion of various entities into the LLP. Now coming to the second point, all the partners of the firm shall be the partners of the LLP, which means there shall be no new partner, or the existing partners cannot cease to be a partner while making the application. So no new partner can join, and no partner who has given his consent for the conversion will cease to be a partner of the partnership firm. It is mandatory for all the partners to hold a valid digital signature, because all documents are to be filed online, and manual signatures are not possible on the e-documents. So all the partners must obtain digital signature certificate, which will entitle the partners to put their digital signature on the digital documents. And they must have DPIN. DPIN stands for Digital Designated Partner Identification Number. The partnership firm to be converted must be registered under the Partnership Act 1932, because partnership may be registered or may not be registered. But if the partnership firm needs to be converted into the LLP, then the firm must be registered under the Partnership Act 1932. All the partners' consent must be obtained. All the partners should give their consent. that they would like to be converted into the LLP. The LLP must have the same partners as that of the partnership firm. Any partner that wishes to be removed from the LLP may be removed after the conversion is complete. It means during the process of conversion, no partner will join that conversion and no partner will be allowed to leave the partnership firm. So they will be allowed to leave the partnership firm only when the conversion is complete. DPIN or DIN. DIN is Director Identification Number and DPIN is Designated Partner Identification Number. Must be obtained for all DPs, that is Designated Partner. And now friends, I'm going to take up the heading Procedure for Conversion of a Partnership Firm into LLP. So step-wise procedure I will discuss. There are various steps involved in the conversion of a partnership firm into LLP. The very first step is name approval and DSC. So first is the name approval. Regarding name approval, I would like to discuss few points. Register and subsequently log on to the MCA portal. Okay. Second is under the MCA services tab, the Run LLP option is to be selected. What is RUN? RUN stands for Reserve Unique Name. And in the drop-down list, the option conversion of LLP into LLP, conversion of firm into LLP is to be selected because we are going to convert the firm into LLP. Subsequently, there are two proposed names for the LLP to be given. After that, any supporting documents may be uploaded in the PDF format, after which the submit button is to be clicked on. The page is redirected to a payment gateway where the fee of ₹200 is to be paid for the form. The reserved name then holds a validity of 90 days. Remember friends, this reserved name, whatever name has been reserved, this will be valid for a period of 90 days or we can say 3 months. Now B is Digital Signature Certificate. Digital Signature DSCs. After the name incorporation stage, it is mandatory that the designated partners of the LLP possess their their own digital signature certificate. Every e-form requires digital signature certificates of the designated partners to be affixed to the relevant forms in order to ensure a successful submission. Now coming to the second point, which is filing of forms with the ROC. ROC stands for Registrar of Companies. Now forms are, one is A Form 17 and second is Philip. Now this A Form 17 is an application and statement for the conversion of a firm into LLP. The form is divided into two parts. Part A is application and part B is statement. And now the question arises, what information is required to be filled in the application form? First of all, service request number of the RUN. And RUN, you all know the full form of RUN in the LLP form. Second is name of the proposed LLP. Name, address, registration, partnership agreement, details of the firm. Details regarding the name of partners, capital contribution to be provided. Secured creditors details. Whatever is the number of secured creditors, their details has to be provided. And apart from this, there are certain attachments which are to be provided along with this A Form 17. And these attachments are statement of consent of partners of the firm, statement of assets and liabilities of the firm, which would be certified by CA in practice. Copy of the latest in ITR acknowledgement, list of all the secured creditors with their consent. A statement shall be filed by the partners with the registrar, stating the name and registration number, if any, and the date on which the firm was registered under the Partnership Act 1932 or any other law. The incorporation document is a very important document pertaining to the incorporation of LLP. So this document, along with the statement in the prescribed form made by the chartered accountant or CS or cost accountant or advocate, now who is engaged in the formation of the LLP, and anyone else who subscribed to the incorporation document shall be filed with the registrar, stating that all the requirements in respect of incorporation have been compiled with. So all these formalities have to be fulfilled. So this declaration has to be given by CA, cost accountant, CA or cost accountant or advocate, that all the formalities relating to the formation of LLP, they have been fulfilled. So B form is filling. This is the form for incorporation of LLP. Information required to be filled in the application form. That is details of the run, registered office address and email of the ILLP, office of the registrar, nature of business activities. What is the nature of business activities of this proposed LLP? Then details of the partners, DPs, their DINs, their DPINs and PANs, etc. All are to be provided in the billing. Even the amount of contribution which has been made by the partners in the LLP. Now the attachments which are to be provided here are proof of address of the registered office of the LLP, subscriber's consent, NOC, no objection certificate from the property owner, and copy of utility bills not more than 2 months old. They should not be very old one, but they should be just 2 months old. Approval of any regulatory authority, if it is required. Then details of any LLP or company where a DP is also a director or partner. Proof of identity and address of the applicants. Where the name of the LLP is identical to any existing company or LLP, or copy of the board resolution or consent of the existing LLP serving as a no objection certificate. So any NOC has to be obtained in that case. Both the forms are to be e-signed by the proposed designated partners and certified by chartered accountant or company secretary or chartered accountant, or any of whom must be in the full-time practice. The fee to be paid will vary in relation to the amount of capital contribution. Now coming to the step 3, which is obtaining certificate of registration from the ROC. Now, issue of certificate by ROC. So all the documents I've discussed, friends, the ROC will receive all the documents and will examine all the documents. And if the registrar is satisfied with all the formalities and filing have been complied with, he shall register the documents and issue a certificate in form number 90. Stating that the LLP is registered with the name and form, the date specified in the certificate. The certificate of registration shall be the conclusive proof of the conversion of the LLP. Now, power of ROC to refuse conversion. Now, if the conversion has been applied, then and ROC is not satisfied with the formalities, then in that case he has the authority to refuse the conversion in case he is not satisfied with the details of the information which has been filed as required by the Act. Now, appeal to the tribunal in case of refusal. Let us presume, the ROC has refused the conversion. In that case, the applicant may apply to the tribunal within 60 days from the date of receipt of such information of refusal. So step number 4 is about LLP agreement, drafting and submission of LLP agreement. The LLP agreement has to be submitted in form LLP 3 within 30 days of the incorporation of LLP. It shall contain the following particulars. Because LLP is not mandatory, it is not necessary that LLP agreement must be drafted before the registration. So it has to be drafted, and it can be drafted and submitted in form LLP 3 and which has to be submitted with the ROC within a period of 30 days. So what are the contents of LLP activity? They are name of the LLP, name of the designated partners and other partners, form of capital contribution, and profit sharing ratio, rules governing the LLP, rights and duties of the partners. These are all the contents of the LLP agreement. Now, the next step is the last step in the conversion of partnership firm into LLP, which is informing the registrar of firms about conversion. In case the partnership firm is registered, then the converted LLP is required to inform within 15 days from the date of registration of LLP to the registrar of firms, with whom it was registered under the provisions of the Partnership Act 1932. Now, this particulars are to be given in form number 14, and the form has to be accompanied by copy of the LLP incorporation certificate and copy of the incorporation document submitted in form PILIP. So, incorporation document is a very important document pertaining to the registration of LLP. Effects of registration of conversion. There's a last heading which I'm going to cover. Effects. What are the consequences of registration of conversion? Let us presume all the formalities have been fulfilled and the registration has been, it is complete now. Conversion is complete now. All formalities have been fulfilled. The LLP has been given the certificate from the ROC. Then what are the effects? The very first effect is if existence of LLP. LLP shall come into existence by the name which has been specified in the certificate of registration. The second is automatic transfer and vesting of assets and liabilities. All tangible, movable and immovable, intangible property vested in the firm, all assets, interest, rights, privileges, liabilities, obligations relating to the firm and whole of the undertaking of the firm shall be automatically transferred to and shall vest in the LLP without further assurance, act or deed. Dissolution of converting entity. And converting entity was the partnership firm. The partnership firm shall be deemed to be dissolved and its name will be removed from the records of the register of firms. So there are certain additional consequences of the conversion. These were the three main points. And now hurriedly, I would like to take up these additional consequences of conversion. All proceedings which were pending against the firm may be enforced against LLP now because a firm has been dissolved and now the LLP has come into existence. Any order or judgment either in favor or against the firm may be enforced against the LLP now. All existing contracts and agreements in which the firm was party shall continue to be enforced with the LLP as a party. Every existing appointment of the firm or authority conferred on the firm shall be as if it was conferred on the LLP. Now, the very small heading and the last heading I would like to take up now, which is partners' liability before conversion. Every partner will be jointly and severally liable for all the liabilities and obligations of the firm, which were incurred before such conversion. And if any partner discharges the obligation, if any partner has discharged the obligation, then he shall be indemnified by the LLP. So friends, this is all about the various headings which I have covered. There is a need for conversion. What is the meaning of conversion? And when is the partnership firm eligible to be converted into the LLP? And then after that, what is the procedure for conversion? And what are the consequences and effects of conversion of partnership firm into LLP? All these headings I have covered in my today's video. And if you have any doubt, friends, you can always write in the comment section. I will always answer at the earliest. It is all about conversion. It is all about today. Do press on the bell icon so that you can get notifications of my subsequent videos. Keep smiling and stay blessed always. Goodbye, friends. We'll meet soon.